Sylvia.
Mr. Speaker, according to the Ministry's media release of 1st August, the rationale for this bill is to enable law enforcement agencies to more effectively carry out their duties while safeguarding personal data. The bill enables more DNA to be collected from suspects, offenders, volunteers, and others in order to have a larger DNA database for comparison with evidence obtained from crime scenes. There may be discomfort in some quarters due to the expansion of the net for collection of DNA. From the existing pool of registrable crimes, this bill widens the net by enabling DNA collection for a new class of eligible crimes, which will include all offences punishable by imprisonment which are not compoundable by a public officer under the law. It can be argued that actually, the current legislation already enables DNA to be collected for many offences which the average person may not consider serious, such as infringement of copyright and possession of uncustomed cigarettes. Now, the bill proposes to include less serious offences, such as voluntarily causing hurt. This raises the question of what the appropriate threshold should be to justify the collection of DNA from individuals simply for the database. In other jurisdictions, this has sparked discussion about the balance between the public interest in securing evidence to prove or disprove guilt versus the public interest in ensuring that private individuals are protected from unwarranted interference. These questions should not be dismissed as unimportant. At such times, it is appropriate to step back and ask what Singaporeans should expect out of the criminal justice system. While we should always be concerned about treating suspects and offenders fairly, we need also to remember that victims are critical stakeholders who tend to be overlooked. For instance, while a victim may have suffered harm, criminal justice systems are such that the decision makers in the case will be the prosecuting authorities, with the victim's wishes sometimes being overruled. To that end, the evolution of technology, if correctly applied, can result in bringing to more victims the justice and closure they deserve. To illustrate my point, I wish to share a vivid personal experience from my days in law enforcement. It is public information that in the 1990s, the Singapore Police introduced an investigation tool known as AFIS, the Automated Fingerprint Identification System. The system automated the matching of fingerprints lifted from crime scenes with those stored in a database of convicted persons and suspects. The implementation of AFIS at that time resulted in the resurrection of many old case files where fingerprint matches were suddenly found. I remember being assigned one such case. A fingerprint from a housebreaking scene was found to match the print of a person then in prison for another offence. My colleague and I then proceeded to visit the prisoner. He initially denied any involvement in the matter. However, when it was pointed out to him that his fingerprint was found at the scene, he immediately recanted and admitted that he had indeed broken into the flat. As I listened to him narrate what happened, I was struck by how his description of the position of the windows and the furniture and where the elderly female victim lay asleep corresponded exactly with the scene found by police many years earlier. He was thereafter charged with this old offence and sentenced by the court accordingly. It was indeed gratifying to know that technology worked correctly in that case to bring justice to the elderly woman, albeit years later. If enhancing the DNA database will result in more cases being solved and bring justice and closure to more victims and their families, that is an outcome we should support. At the same time, there is the important issue of safeguarding personal information. As mentioned by the Leader of the Opposition earlier, we have looked at how DNA collection is managed in other jurisdictions, including Australia and the UK, two jurisdictions which the Minister of State referred to earlier. Sir, the bill before us no doubt widens significantly the state's powers to collect DNA from individuals. However, we see some attempts to limit the scope of the state's powers. I will cite just two examples. First, as far as what types of DNA samples may be collected, Clause 2 makes clear that though the minister may prescribe additional types of samples that may be collected, he cannot include samples obtained from more private parts of a person's body, such as the genital areas. A second example of scope limitation is found in the proposed Section 25. This section states that while reasonable force may be used to take body samples where the person does not consent, use of such force does not extend to taking an invasive sample, such as a blood sample. I support these and other limitations on the state's powers. That said, I have concerns about two particular aspects of the bill which I believe need to be clarified. First, on volunteers giving their DNA samples. Under the current Section 13 D of the Registration of Criminals Act, a person may volunteer to give a body sample if he was present at the scene of the crime or if he is being questioned in connection with the investigation. In this bill, the proposed Section 23 will expand the potential net of volunteers by enabling any volunteer to provide his sample, even if there is no nexus between the volunteer and the crime. So I note that such a provision does exist in other jurisdictions, so in principle, I do not object to the change. However, the question is, how will this operate in practice, and in particular, whether vulnerable groups may be pressured to provide blood samples, thinking that they have no choice but to volunteer, in quotation marks. Already with the current Section 13D, I had noted previously in this House the case in 2008, 14 years ago, of blood samples being taken from 200 foreign workers in the aftermath of an attack on a student at Clementi Woods Park. When I filed a parliamentary question on this in 2008, the ministry replied that the blood samples were drawn after the workers had voluntarily given their consent. I do not know how the consents were obtained from the 200 workers to draw the blood samples. However, one could well ask to what extent the workers were worried that non-cooperation would jeopardize their employment in Singapore. With the expanded powers to collect body samples from just about anyone who volunteers, what safeguards will be put in place to ensure that vulnerable groups are not picked on and that the consent of volunteers is informed and freely given? So my second concern is about the proposed Section 27. This section makes it an offence to refuse to consent to give a body sample when one is liable to give it. Although refusal to consent is already an offence, the proposed Section 27 creates a new offence if a parent or guardian of a child refuses to give consent for a body sample to be drawn from the child. Although it is right to seek the consent of the parent or guardian in the case of a child, is it appropriate to inflict punishment on a parent or guardian who does not give consent to an invasive procedure on his or her child? Are there other jurisdictions where parents are punished in this way? So finally, I should end on a note of caution. While DNA profiling has certainly been a game changer for law enforcement, there are limitations. From what I understand, DNA profiles lifted from crime scenes are often incomplete and hence less helpful in identifying a particular suspect. Such partial profiles will also match with many people. There is also the risk of DNA being contaminated at the crime scene or being brought there by secondary transfer, that is, a person who was not at the scene may have his DNA inadvertently or even deliberately brought there by someone else. It is a fact that there have been miscarriages of justice in other jurisdictions involving DNA evidence, such as wrongful convictions due to mix-ups in the laboratories handling the DNA. So we must be alive to all these risks and demand the highest standards in our investigations, including in the handling, processing, and analysis of DNA samples. The relevant agencies, including our courts, should also be mindful not to regard DNA evidence as infallible, but to assess it in the light of other evidence so as to minimize the risk of wrongful convictions.